Is the UK losing its marbles? So what do I mean by that? Well, in a bit of a change for my ostensible art law channel, some actual art law channel. So what I'm going to talk about today is something called Deaccession. So what's that got to do with marbles? Well, I'm thinking of the Parthenon marbles, as I call them, because one of my friends acts for the Greek government in trying to get those back. And I'd like to keep my kneecaps, so that's why I'm not calling them the Elgin Marbles. Although technically Parthenon marbles isn't correct either, because some of the marbles that they actually want back aren't from the Parthenon. But the government has said, well, even if we wanted to give them back, we can't as a matter of law. So is that correct? Well, yes it is, because museums and galleries, when they acquire objects, they're quite often restricted in what they can do with them. And they have what we call deaccession policies. So that's, can they actually give them back? And some of those are matters of law when it comes to national state-owned galleries, because, they get this material and they effectively hold it on trust for the nation. So they can't just necessarily give it away. But what are some of the criteria for whether they keep things or they can get rid of it? Museums, for instance, they don't have to accept artwork or keep artwork or material. It doesn't have to be artwork, it can be historical artifacts. If, for instance, it's just not suitable for the museum. So, if you leave your collection of Picassos to the Natural History Museum, they might say, well, there's no pictures of dinosaurs here, so they're not really relevant to us. Also, if it's just not in a fit state to be kept or exhibited, it's rotting away, it's all gone mouldy, it would just cost more to maintain and keep in a suitable environment than it's actually worth. Also, if they have duplicate material, so if they have more than one of something, then they can get rid of the duplicate. Although obviously that's not, written in stone. It's on a case-by-case basis, just because they say, well, we've actually got 2 Gutenberg Bibles now, so we can get shut of one. Or we've got nearly all the Lindisfarne chess pieces, so we'll get rid of all but one of them. But generally speaking, unless it ticks one of those boxes, they have to keep it, because like I say, they're holding on trust. There are some slightly different rules when it comes to human remains. Although again, they do still keep them. I mean, in France, it's actually in the Constitution that anything that's in a state gallery belongs to the people. And they actually have to amend the Constitution if they want to release anything, which they have done in a couple of high-profile cases in regards to human remains. Also, museums and galleries can de-access to other museums and galleries, so they can swap them around. But the idea is that once something is in, sort of the public domain, so members of the public have access to it, then it should remain so, and it shouldn't be sold off into private hands just to disappear. But what about private art? What about if it is in your private collection and you want to sell it? Can you? Yes, but with provisos. There's something called the Waverley criteria. So if somebody wants to sell, a valuable artwork or historical artifact in this country and it's going abroad, it would need an export license. And if the object ticks one or more of the following boxes, then the Waverley Committee, which is an NGO, that's just a bunch of people who know about art and history and museum type things, they can put a block on the granting of an export license for a period of time, whether it's 3 months, 12 months or whatever. The idea being that gives time for concerned people to raise money to try and keep it in the country. So what are the Waverley criteria? They are if the object has a strong connection with the United Kingdom, it's historically important, like the Bayeux Tapestry or the Stone of Scone or something like that. Also, if it's just a particularly aesthetically pleasing work of art, if it's a genuine masterpiece. Although, just to be nerdy, and I know you like trivia and diversions, technically speaking, a masterpiece is the piece of work you exhibit for admission to a guild. So back in olden days, if you wanted to join the Silversmiths Guild or something like that, you would create a piece and you would show that and say, this is the work that I am capable of. And they'd look at it and go, okay, you're in. So that was your masterpiece. So technically, you can only have like one masterpiece per person, because the idea is it's meant to be the best example of their work. And the other criteria is if it is useful for research or education. So say, for instance, all the Babylonian stone tablets, the way people are trying to decipher linear A and linear B and all those sort of, old Akkadian languages and things like that, then, that's another reason for keeping them in the country, because, it needs access to research. I mean, this is a big problem now with, just to go off on a little bit of a tangent, it's like with Egyptology. The problem for Egyptologists is that Egypt gets about 80-90% of its income, tourist income, from people who read Graham Hancock books. They want the mystery of the pyramids. They don't necessarily want to, have it all demystified and debunked, how old is the Sphinx. So the problem there is they're not actually allowing people to do research. Or when they are allowing people to do research, it's on a commercial basis. Sorry, just have a sip of my coffee. Oh, that is nice. It's on a commercial basis. So they will do something like all this muon scanning of the pyramids, but they'll do it as part of a sort of TV series or a documentary or to publish a book. And then the information they get, normally, proper scholars will release all their raw information for people to try and analyse themselves. But what they're saying is, well, no, this is, proprietary IP. It's secret. We paid for this. We're keeping it. We're not releasing it. So, that's the flip side. But over here, the idea is that you should make this material accessible to people. You should be able to sort of write to the British Museum and say, we want to study these tablets because, we want to have a go at translating them ourselves. Oh, another thing is, can museums refuse bequests? Actually, it looks now like they can do. So don't just think you're just doing a bit of a loft clearance and you're just going to dump it all in the Victoria and Albert Museum. You can't do that. What about, stuff that's been nicked either from your country or from your family? Well, this again gets very, very complicated with deaccession, because when it comes to cultural artifacts, we call it cultural heritage now. We used to call it cultural property, but the idea is that had an implicit bias, because not everybody, all cultures have the same idea as property as we do. If you say to sort of Australian Aboriginal who owns Uluru, Ayers Rock, they're going to say, well, nobody does. How can you own it? It's always been there. I mean, somebody once said, if you wanted to give directions to aliens for how to find us, you just say, we're the planet with the big red rock. And I quite like that. Now, as a matter of law, Uluru is in the custody of the local tribes and the government. They both hold it jointly on trust. But because really the tribes are going, well, okay, we're doing that just so we can have some control over it, but realistically, we don't think anybody owns it. It belongs to it itself. So that's what we call, the cultural heritage now. But one problem is, who do you give it back to if it's been nicked? Populations change, boundaries change. Say you got Mesoamerican artifacts. Well, some of those, the Mayan Empire, the Aztec Empire, the Inca Empire, they don't really correspond with modern boundaries. So say you find something in a museum, unless you can show which site it was originally taken from, which now modern country gets it back. There was a very interesting case, actually, with a treasure ship. There was a treasure ship found in the waters just off the coast of Peru, and it was laden with gold that they were using to sort of, pay the soldiers, pay the bureaucrats back in, the days of the Spanish Empire. And it was literally worth billions. So Peru was going, well, this is fantastic. It's in our waters. Yay, we're quidsing, guys. But Spain said, well, no, hang on a second. When this sank, Peru was just part of Spain, and this is a Spanish ship. And if you wanted all that independence, well, good luck to you, you're independent now, but that means that gold is all ours. And that actually went to court, and Spain actually won. And there's a similar thing with the Benin bronzes, the ones from Africa. The argument there is, well, if we give them back to the government, the current government are the descendants of the people who stole them and sold them to the Westerners in the first place. So that's just, receiving stolen goods back to the people who stole them. I mean, it all gets very complicated. You find a statue in the Mediterranean and it's like, well, was this done in a Greek colony on Roman land, or was it done in a Roman colony on Greek land? Was it actually done by Greeks or Romans, or was it just, because there's this idea that even some of this sort of material in the Far East in China was actually produced by sort of, jobbing Greek sculptors who they would just pay to come over and do things. So it all gets very complicated in terms of giving it back. But what about personal property? What if, and this is what we talk about provenance with paintings. The provenance is like the history of a piece of art from when it was produced up to where it is now, and the idea is that you should always be able to trace it. I mean, people go to massive efforts to fake provenance. People have broken into archives and created fake auction catalogues and fake museum listings and things, so that then they can produce a forgery and say, well, in terms of authenticating it, let's have a look at the archives and see if there's any history of this. Hey, look, here's a picture of it. Some guy actually did an amazing thing where he produced a fake painting in the style of a particular painter. He snuck it into a stately home where there was a collection of artwork by this painter. And he got his sister to go in there, dressed up in period dress from the 19th century, and they took some photographs on a really old camera to get the authentic 19th century thing and made sure this painting was in the background. And then they smuggled that painting, they produced like a pamphlet about the history of that house and slipped it into some sort of like local sort of second-hand bookshops. So when this painting mysteriously appeared, I was going, oh, is this a lost work by this particular person? Obviously they started looking through all the archives and somebody said, hey, have you seen this? There's an old leaflet here advertising the house and there's a photograph in it and you can see that painting is in the house. So, that lent to a lot of credibility. But other people, like I say, have literally just gone into the archives, and literally cut and paste and created fake catalogues, because, these things can be very valuable. But what if, the provenance is something like, a painting was last seen 1939 Warsaw, and then suddenly reappears in 1946 Switzerland, the property of Baron von Julingscar. And you recognise that. Can you get it back? Well, yes, but you do a claim. Now, interestingly, you do a claim in what we call Replevin in most of the world, except here where we call it conversion. Conversion is the civil equivalent of theft. If somebody swipes something of yours, nicks something, and you want to get it back, I mean, obviously they've committed an offence, but also you might want to bring civil proceedings to get it back. So you can either sue and say, I want the property back, or if the property is no longer available, they've parted company with it or something, and you don't know where it is, you say, well, I want compensation in lieu. And now, technically speaking, asking for the physical item back, you are suing in Replevin. And the alternative is conversion. That's where you say, well, okay, I'll have damages instead. In England and Wales, rather boringly, you're just suing conversion, and you say, I either want the thing back or I want the damages. But then you come into limitation, because obviously you've only got a certain amount of time to bring claims. And the time runs from when you have knowledge that you have a claim. So if your painting has gone missing and you suddenly spot it, and it's 70 years later after the war, then actually you can say, well, that's the first time I could have sued because that's the first time I knew where it was. However, you've got to be careful. There was a case, Liz Taylor. Liz Taylor's dad was a famous art dealer. And when she married Richard Burton the first time, as a wedding present, he said, pick a painting. You can have any painting you want. And she picked a particular painting, and her dad bought it for her as a wedding present. Now, many years later, it turned out that was looted Nazi, been looted by the Nazis. Many years later, that came to light, and she and the family sued and said, we want our painting back. The problem there is, they said, well, when you could have sued earlier. I said, well, we've only just found out about this. But they said, no, by the time of the original wedding, it was reported in the society paintings that she'd had this present as a wedding present. So it's not when you spotted it, it's when you could have spotted it. And the argument was, no, you could have known about this earlier. So I suppose the moral there is, read all the gossip columns and the celebrity things. They did actually introduce a law in New York a couple of years ago to remedy that, and they extended limitation. And they said, okay, for the next few years, we're going to say, if your claim would otherwise be, statute barred for limitation, we're going to give you a chance to bring it. I mean, that period has now passed, but that just gave people a chance to try and recover their artwork. And then a lot of times, actually, especially with museums, you hear some horrible stories of museums really putting up a fight. I mean, their argument is, look, we are trustees, we have a duty to the museum to try and keep it. So we're not being horrible, we're just, trying to protect the rights of the museum. But in the number of cases, the family has won the case, and they said, yes, this is your painting. And then they've let the museum keep it. And they said, oh, no, you can keep the museum. We want it to be on display. We just want the acknowledgement that it was stolen from our family. So now a lot of the time, actually, there are a lot of settlement agreements, which is, yes, we will acknowledge that it's your painting, but you let us keep it. I mean, sometimes we've been very cheeky, though, with some, cultures and things where we've swiped things. There's a particular thing where there was a totem pole swiped from a Canadian First Nations tribe. And the deal was, we'll give you it back if you make us a duplicate of it. It seems a little bit cheeky, but it's a bit like with the Parthenon marbles. We've always said, well, we can't give them back because you don't have anywhere nice to keep them. Now, as it happens, Greece has a really good museum ready to go. And in all fairness, I've seen the Parthenon marbles in the British Museum, and it's not like they're particularly well displayed there. I mean, you just walk into a room and they're just lying around the sides of the room. It looks like they're spring cleaning. But it's a bit cheeky, I think, because, if somebody nicked your car and said, well, you're not getting it back unless you build a better garage, I think you'd be, a little bit aggrieved about that. But those are the criteria. So these are the problems. And, this is why it can be hard to get materials back from museums and galleries, whether it's cultural property, because first of all, it's like, do you have standing to even bring the claim? What is your connection with the people that this was originally stolen from? When it's sort of personal stuff that's stolen from families, it is a little bit easier because you can say, look, this is our family and I would have been the beneficiary had it not been stolen. But, you get into all sorts of arguments about, well, was it really stolen? I mean, Goering was famous for just going to Jewish families and going, I would like to buy your entire art collection for 10, for like 10 marks. And you either sell it to us or you're going to find yourself not living here anymore and living somewhere with lots of barbed wire. So was that really a sale? Was that a legit sale, or was it a forced sale? Was it coerced? I mean, the American government did a terrible one recently with the Goering material, some very valuable artworks. And they have resisted the claim on the grounds that at the time, Jewish people had no property rights. So as a matter of law, this couldn't have belonged to the family at the time. So therefore we're going to apply. I mean, it's a bit of a, to see in the sort of 21st century, the American government saying, well, no, the Nazis were the legitimate government and we're not going to interfere with that. I mean, that was a little bit shocking to everybody. But that just goes to show how hard it is to get this material back and how strongly museums and galleries will fight for all that. But anyway, as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate, possibly vaguely depressing. Where am I today? I'm at a place called Cows and Sows, which is like a little cafe stroke, shop stroke, art collective, therapy centre, just in those woods that I like, in Idlis Woods. So what I'll do is I'll finish my coffee and my cake and I'll try and get you a little bit of B-roll. But it seemed a nice place to come because it is, really, really arty. And they have lots of pretend animals.